We have one item under old business that is a resolution authorizing an agreement with Cornerstone Commercial Partners to represent the city of Prospect Heights to market and sell city property at 2535 Piper Lane.
All right, we have a motion to approve that.
So moved.
Second, please.
Second.
All right, discussion. Alderman Messer, you had some questions.
Yes, should I direct it to the
Yeah,
representatives?
why don't, Peter, at least if you would come up and we'll holler for your partner if we have to.
Good evening. Peter Carlis from Cornerstone Commercial Partners.
Hi, Peter. I just had two questions on the wording in the agreement. I don't know if you have a copy of it in front of you or if you know it by heart.
I don't, and actually Ron might be the better person to address those two, but I'll do what I can.
Okay, in the second paragraph, it says that the full commission is to be paid at closing, which in the case of a sale or contract for deed shall be at the time buyer and seller execute the initial contract or agreement for deed. That sentence is conflicting to me because to me, closing is at closing once everything's finalized and disbursement and funding is authorized. And at the time the contract or agreement for deed is entered into is before closing. I believe somewhere else in the agreement it might mention
Could I?
something closing, but I just want to make sure that the agreement's clear in the wording. I don't know if we just cross off the last end of that sentence, just says full commission is to be paid at closing, period, and strike the rest of it.
Sure. The terminology you're referring to is a trade term. Agreement for deed would refer to a contract by which the purchase price for the property would be paid over a number of years instead of all at once. So in the event that the city entered into agreement with a prospective purchaser to pay X amount of dollars over 25 years and a certain amount per year, we would appreciate not waiting 25 years to obtain all of the commission on that. As a practical matter, it's a boilerplate language that's in there. The situation is so unlikely that it would even arise, but I'm sure we could adjust it to accommodate.
All right, Counselor?
Yeah, I mean, just because it does say the initial contract or agreement for deed, so if it were just clear that if it were the initial contract, and if you mean purchase contract, then closing, and if it's an agreement for deed, then it's worded that way.
Mayor, if I may, Alderman, it could be worded a little better, but what Mr. Carlos is saying is correct in that a contract for deed is typically an installment purchase agreement, and we don't do those in Prospect Heights, but in any event, if they tried to collect a commission from us upon the signing of a contract, we would steadfastly refuse to pay it, and I believe that we would prevail. So with that explanation, Alderman, if you're comfortable leaving that language, I can tell you I'm comfortable with it, and we can certainly adjust it if you'd like, but that is an industry term, an agreement for deed. It's a weird one, but...
Yeah, it was just since it kind of lumped in the contract part with it, but if you're comfortable with it as our legal counsel.
I'm happy to say I would recommend not paying them when we sign a contract.
Ever, not even 25 years. Anything else?
Yeah, I had one other question or comment. For 5B, it references that if the transaction fails to close due to the fault of a buyer, that the earnest money would be distributed to the seller less any costs or advertising. And again, maybe I'm just being picky here because the contracts I deal with are very specific in how they're written. To me, due to fault of buyer is not saying like a default, because there are times when a contract doesn't close and it could be the buyer's fault or buyer's reasoning, but they're not technically in default and the earnest money is still returned to them. So then my only thing would be is assuming that the fault actually denies the buyer the right to have a refund of the earnest money and where it is being released to us as seller.
The intention of that paragraph is to apply only to a situation, excuse me, a situation that you're referencing where the buyer would be in default and forfeiting the earnest money. Either the language.
So that's the intended language. We've got it on record, so that'll satisfy me.
Okay.
Yeah, just the way it read, it wasn't really, specific, so, and I
I understand.
I think, for
Not
example, if I
significant.
could throw something out, if, let's say, the transaction was subject to getting financing, and he was turned down, well, then we would, of course, refund the earnest money. But I'm thinking of something bizarre, a default.
Unless their financing contingency had expired, in which case then it would be a default and be able to come to the seller.
As a practical matter, it would only take place after all contingencies to the buyer's obligations under the contract had been satisfied or waived, and we're in that period just waiting for closing, and then they default.
Yeah. I mean, basically, you're saying that this language is meant to be pursuant to the terms of the contract that would deny the buyer a right, so.
Correct.
Even though it's not clear in the language here, the explanation and it being of record in our minutes will satisfy me.
All right, Alderman Rosenthal.
No question.
Alderman Ludwigson.
Yes, a few. There is a resolution along with this contract. I don't know, is that new that we do resolutions to enter into a contract if we have a contract to sign?
Hey, we discussed that. Michael, you want to?
Sure. Alderman, you raise a good point, because we do have a resolution declaring the surplus from a year ago. So the resolution really isn't necessary. We could just approve the contract on its own to list it with the broker. It's really the council's preference, because if you look at Section 1 and 2, Section 2 is really the operative provision here, which is just approving the agreement. So that could be done either by resolution or by motion, but if the alderman was concerned that this conflicts with the 2015 resolution or maybe sends mixed signals, I certainly have no problem legally with you just approving this by motion.
I was just more curiosity why, because typically with contracts, we'll just enter into them as long as it's within the parameters of whoever's signing it. So I just thought it was weird that we had a resolution.
Yeah, I don't know who drafted the resolution, Alderman, so maybe if we ask that person, I don't.
They didn't look like your form
No, it's
resolution.
not.
It definitely
Who
wasn't.
did the resolution?
Administrator Wade drafted the resolution.
Okay. All right, the other thing was the $3,000 for basically the marketing, the cost for the printing and that. Is that typical? That given that this is not a $60,000 condo business unit or something, I would see that more in something like that. But something of this size, I know it's not huge either, but to ask for the $3,000 for the marketing, because I thought that's what you guys were doing.
Just flipped. I mean, a $60,000 condo on Old Willow Road, no.
No, I'm talking about like a business condo, like a unit. We have one of those on Rand Road, where it's a really inexpensive commercial piece of property where it'd be difficult for you to, even at 6%, get what you would need if you're going to do all the printing and marketing and all that. But on something of this size, is that normal?
I would say in many cases, yes. I mean, because of the magnitude of the piece and, drilling down, this is not exactly a walk in the park. This is going to be, we're going to be spending a lot of time, a lot of effort, a lot of marketing, signage, postcards, direct mail, things like that, just to shake the bushes. Could be cranes, it could be local paper, this and that. So I'd say in many cases, properties of this magnitude, yes, we do get marketing fees.
Okay, and then the other thing I noticed in there is that on the rider, when it comes to the rider A, when it comes to being the dual agent, you only reference the two of you. Although the marketing info had, I don't know how many people, 7 people listed as agents in your that work with you guys. Why are they not? Why is it only you two and not just anybody who works for or is associated with your agency?
Well, we would be the designated agents, so the only legal agents of the city for Cornerstone. As a practical matter, a lot of the other members of Cornerstone, a lot of the other brokers in Cornerstone don't necessarily do the same type of brokerage that we do. So
The concern would be somebody in your office has somebody. They're not going to want to give that up. They're going to come to you, and you might be able to do the same arrangement, but now because they're kind of outside of this situation, we wouldn't be entitled to that.
Well, I think to some degree, Pat, there's, and it's amazing, some of the things that we get in our inboxes every day, or indirect mail or whatever, as far as incentives go. It's just one of the most bizarre things I ever saw was that if you lease this industrial building before the end of the year, you not only got a full fee, but you drove away in an Audi TT for 2 years. I mean, there's some bizarre incentives out there and this and that. And I think to some degree, if Peter and I are in fact dual agents representing both the city of Prospect Heights and the buyer, we figure we'd like to shave that a little bit. It's a win-win situation. However, then again, too, if we have somebody in our Chicago office or somebody in our Arlington Heights office that brings a buyer, why is it really fair to him to, let him take a hit, And once again, we like to cooperate with all brokers.
No, I get that, but I mean, as part of the, part of what you put together was that you're bringing this team of people that are going to market this, try and sell it, and be involved with it, but it's only you two.
Could I perhaps try to answer that in a different way? We'll be the only ones really that are focused on this as our primary responsibility. All the other brokers at Cornerstone have their own individual specialties, and they're off doing their own thing. It would be a bizarre situation to have the other Cornerstone brokers less incentivized than brokers working at other companies to bring their clients and prospective purchasers in to see this parcel.
Okay.
So the discount is in the case that the two people that happen to be working on the property anyway, obtain a buyer directly. For all other brokers out there that aren't undertaking this responsibility, we all want them equally incentivized to bring their purchasers into this parcel.
So you go to all brokers, and you pay a co-op fee to all brokers?
Absolutely.
Absolutely.
Well, all brokers meaning whoever brings a deal in.
Well, correct, yes.
What's your split on the co-op?
50-50.
Yeah, it was 50-50. Yeah.
50-50. We don't play games. You've been in the business, Nick, Mr. Mayor. There are a lot of companies that, bring me your co-op buyer, and next thing you know, they're not paying 50-50, they're maybe giving you 40%.
Right.
The listing agent is giving or keeping 60%, or the listing company. No, we don't play those games.
All right.
One more question,
Yes, sir.
and then a comment. Are you expecting that you'll have to come to us for any variations before you start marketing this? Because, I mean, you're aware that this is a B4 zoning, not the B3, that everything else is around there. And the B4 was primarily set up to allow for the arena 25 years ago when it was set up. So this is still under that zoning.
Well, we would not be asking for any sort of use variances or changes during the marketing period. That'll be largely dictated by the prospective purchaser. I would imagine, they would have a contingency time in their contract to allow you to consider their prospective use. But that's nothing that we would change in our agreement with the city. And for other purposes such as valuation, I think, we're going to defer those questions to the experts in that, an appraiser. When it comes to uses, we will market the property with a large spectrum of possible uses, with the understanding that the ultimate use has to be approved by the city at the end.
By the same token, I might be talking out of turn, but in a lot of scenarios, you really hit home, it's an I3, it's a heavy industrial or whatever it is. Maybe we'll backpedal a little bit and not really hit hard the zoning, because it's, from my understanding, talking with Dan and the mayor and other people, that there is some flexibility there. So I think we have to see the white of their eyes to see what they plan on doing with it. So I don't think we can go in, if it's B4, yeah, we'll say it's B4, but what did you have in mind? One of those type of situations.
I just think it's difficult to market something, though, if you don't have it nailed down as to what you can do. which brings me to my last, what I want to comment on with this. Being a city, you're right, we create the zoning, we can do what we want. So it's unusual when a city is selling property versus an individual, because you have to get the city involved, and now you got two other parties and the city, and it's just a lot more going on versus just the city listening to a use and then determining whether they want to sell the property, which has come up a few times already in the past 4 or 5 years. I don't know how you go about determining a market price, because I don't know how you would do that not knowing what the city is willing to do. So my last point is, I don't think in this situation that, especially with this piece of property, it's not like we're selling a surplus house that we bought because we thought we were going to do something, and we have a single-family home. The market is exactly what that is, and it's nothing to be interpreted, whereas this has a big interpretation range of what could or could not go there. So I don't know how we do the city justice by listing it, because you don't know what to market it at, because the sky is the limit when it comes to zoning for the city. So when you put out there an asking price, to me that kind of taints the property, because you don't know what the city is willing to do, or what we will or won't do. I mean, the council itself has had wide ranges of opinions as to what it should do with different buyers that have come forward. So because of that, even though I've known Ron for 25 years, I'm not in favor of listing this, because I don't think this kind of property lends itself to that. And I think that the city knows what it's willing to do or what it's not, and should listen to people coming in versus going to a broker, because you're going to stick a price on it not knowing. And I don't know how you sell it that
Well,
way.
let me interrupt you. You're not going to go out and say this land is on B4,
No.
and that's the only customers we'll entertain, and that's the only customers we'll bring to the city. Of course not. You're going to leave a wide spectrum, as you pointed out, of, take all comers. Let's see what they've got. Let's see where they're at, and you bring it to the city for approval. That's really a simplified answer. You never sell anything, and you'd certainly limit your market to maybe 5% of the potential if you zero in on one thing. Okay, it can only be an arena. Well, you're never going to get anywhere with that, because that's where zoning is now.
Sure.
So I have no problem listing it. It's up to us whether we want to accept whatever comes.
Sure. Just to respond to your concerns, the marketing process that we envision is to really, just beat the bushes to drum up all of those prospective uses. And perhaps even bring some in that the members may not have thought of before. It's not necessary to pigeonhole the marketing to a certain type of use or even to a certain price. I've marketed many properties with no asking price. And that, given the number of moving parts on this particular piece of property, that's something that I could recommend doing here as well, because the price will be dependent not only on, the things like it normally is, like density and use, but price could be dependent on how much the city desires a particular use. If we, bring in a use that is extraordinarily pleasant to the area, and at the same time has the potential to bring in a great deal of tax dollars, the city has the opportunity at that point to put a price that use is worth to them, versus anchoring us to one price position that I agree would provide some rigidity in dealing with such a variety of uses and possible uses for the property.
Anything else?
Nope.
All
That's
right,
it.
moving down the line. Who do we have? Alderman Dolan.
Actually, the one question I had is not for Cornerstone, but I guess for you, Mr. Mayor. Have we had any other inquiries directly to the city, or any interest that's been expressed by anyone else?
Well, I've been here 7 years. We had at least 4 or 5 inquiries, desirable land for, uses that was not acceptable to the council.
I was just curious.
Do we have
That's all I have.
Have we had any recent? I mean, does Dan have any that, I mean, is there any activity? Could you say we've had 5 calls in 6 months or
Well,
one call?
there's always activity. Dan, why don't you tell us the latest one?
We've had a inquiry from a national brokerage firm looking at parcels for a potential client. They have not disclosed who that is right now, but they're looking at it, have idea. They've asked us to provide some information on the parcel so they could do some sales to their potential clients to see if the parcel will work. We had another phone call regarding a potential use that was similar to a previous use that was brought before us last year that the council did not think favorably of, or it did not go past the initial spot. Yes, I get calls regularly. A lot of times it's just a fishing expedition wanting to know some information online, but currently there's been 2 in the last couple of weeks that have come in.
Alderman Dolick, you were asking that question. Does that help you?
That's all I have.
All right, we have Alderman Williamson.
Just a comment. Personally, you know, I've never really felt that it was in our best interest to get rid of this property. There's been requests in the past from Public Works to retain 2 or 3 acres of it for their uses because they're kind of landlocked and run out of space. I also don't see how it hurts us to retain the property because we do own it outright now. It is an appreciating asset. It is an asset nonetheless. But, you know, it's not a bad idea for a city to have some property to fall back on. When it comes to a road project, that's where we store all of the equipment for the contractor. So personally, I'm not in favor of listing it. It has nothing to do with Cornerstone. I think it's great. It's done a very nice presentation. So, but thank you.
Can I add one more comment?
Yes, ma'am.
Okay. While some people may think it's an asset, I think it's been a liability for the city for many years. I've heard for over a decade that something was going to be done with the property. Nothing has been done. It's an eyesore the way it is. I run past it, I bike past it, I drive past it. If we're not going to do anything with it, and we're just going to continue to talk year after year after year about what we should or could do with it, but not actually make a serious plan to do something with it, I think we need to get it off of our books. I think we need to try to get some of the money back that we've lost. I don't know if we can get all of it back. But I think unless someone can come and say, we have a serious plan, I've heard Public Works is interested. I've heard from people at Public Works that they don't know of any interest for it. So, I mean, if Public Works has a serious interest in it, then we need to sit down, we need to find out what it is, and we need to make a plan. We need to do something besides just letting it sit there and doing nothing. And we've done nothing with it for years, so if we don't have a plan to do something, then I'd like to see us list it and try to get something for it. And if we can get something that will bring tax revenues or something into, I think we should explore our opportunities. I think it's sat long enough doing nothing for us.
Thank you. Alderman Rosenthal?
I couldn't agree more with Alderman Messer. Let's move on.
And you know, cutting off a parcel 2 acres or so could come as part of the deal, really. Somebody says, I only want 5.5 acres, right? That happens a lot.
Oh,
Yeah, I
absolutely.
can't use 10, boy, I'd like to have 6 acres. I think we still have those decisions available to us, and we just turn things down because it doesn't really fit. I've talked to Public Works several times. They said, we're not getting any more snow plows, we're not getting any more salt domes, we're not getting any more personnel working there unless our town grows. Our town doesn't grow. Where's it gonna grow? We have 4-mile radius. What is their need? And I've asked Jim that, I asked Kataya before that. I asked myself that. I just don't think that we should be holding on to something that has sucked $5.3 or $5.4 million out of our reserve fund.
Mayor,
I really don't.
with all due respect, I didn't make it up. I mean, I was approached by Steve.
Neither did I. Neither did I.
Okay, but I didn't make it up. I was approached by Steve Kataya, who said, I could sure use 2 to 3 acres of that parcel. So if we're going to market it, why wouldn't we just market it as 7 acres?
Well, you were so happy when Steve Kataya was jettisoned out of this city. You were just euphoric.
I don't understand how that relates.
Euphoric. Now you're using
I
that.
don't understand
Now
how
you're
that
using
relates to
that
our
as a
conversation.
comment. Steve Kataya
Don't
was
understand how
responding
that
to you.
relates to the conversation. We're talking about how Public Works would like us to look for that property. You're going into some,
Not at all. You call it deflection. This is a fact. This is a fact. He was not the right guy for that job. He was responding to you. Talk to our guys. You've had a year to talk to Jim O'Neill, for example, or anyone else over there. I've done that. I've talked to both of the people. So don't start jumping on me for something.
Peter, Ron, if we market it as however many acres and we end up, the city has a need for it and we use it, can we change it in the middle, I mean, it's not like if we say it's 10 acres for the whole year term of the contract, it has to, so if Steve's not here anymore, Katai, but if there's someone in Public Works that really feels a need for it, we can still move forward with trying to make something of this property. And in the meantime, if there's a serious need for Public Works, I think we need to talk to those people, and they need to get in here, and we need to make something of it, or if they don't want it, to make nothing of it, but I don't think we should put this on hold.
All right, let me ask this question. We think about this some more, and next week we say, well, why don't we lop off 2 acres? We could change our agreement with you. Is that correct?
Absolutely. And
Alderman Rosenthal.
Is the question now to approve these gentlemen or their firm
It's a-
for marketing
The market.
on a contract? I call for the question.
All right.
All right, well, no, the question is, should we list it? I mean, that's what the question is.
Right.
Right, so I mean, the discussion about whether we should list it is still valid, and we should still be able to discuss it.
could I respond to one of the
But the idea that we're not doing anything about it, I agree with you. We are not actively marketing it. It's not listed in the MLS somewhere saying it's for sale. We used to have a sign, saying it was for sale. We did do more with it back, prior to these times, which were, bad times when it was done. We're selling this to sell it. We're not selling it because we say that property has to be filled with something or there's some mandate that something be done there. We own this property free and clear. We heard the story that the sky was falling the last December 15th because we had a note due. There was no way we could do this without selling it or refinancing it. We hear now that we're almost $1 million up in our revenue, in our free cash. And to sell this now, without a plan as to why we're selling it, other than to just get it off our books. That's the plan, just get it off the books. To me, it doesn't make any sense. I mean, we'll plan little things, what color a ribbon's going to be for something and at what time that's going to happen. But here we got 10 acres of land, and the only thing we can say is we've had it too long, it's got to go. And when you do something like that, you're going to take what comes because the goal is to sell it, not to do what's best, but to just sell it. And I just think that's bad practice.
I think what's best is to sell it. I'm not trying to just get rid of it, but I'm tired of having something sit there and doing nothing with it. For years, I've heard other aldermen sit up here when I would be out there saying, oh, we're going to do something with it. I haven't seen a city council do anything with the property. And when I say not do anything, I don't mean not listing it, not marketing it. If you want the city to retain it and use it for the city's purpose, what purpose is the city going to use it for? What are we going to do with it? How are we going to develop it? I haven't heard any ideas of the city developing it and doing something with the property and turning it into an asset. Some can say it's an asset now, some can say it's a liability. We can say it's neither. It's just sitting there. So if someone, and again, even if we list it now, if someone comes out, hey, as a city, let's do this, let's build, let's develop it ourselves, we still have that option, and we're not going to just get rid of it. We didn't approve the last contract, which from a financial standpoint was the best we had, but for other reasons, it wasn't best for the city.
Well, it wasn't best.
So
It was
to
better
say,
than that.
right, so to say that we're just going to get rid of it might not be best for the city, I don't think that's true, because we don't know all the potential that's out there. Something could come in that we think is best for the city and think it's really great, but if you don't try to market it, you don't know what's going to come in, and we have no other ideas. The city has not talked about doing anything with it. It's aside from marketing. There have been no ideas, nothing brought to the council. Let's do this with it. Let's make our city better by using the land for this purpose.
But does that put us in the best position to sell it? To get the most that we can get for it? Remember, we sold, I don't know if that was before this current council, we sold the front portion that's on Palatine Frontage Road. We sold it for $800,000. We had a contract in hand. The guy kept pushing and pushing and pushing, want a little more, change the conditions. Eventually, a few of the aldermen said, you know what, we're done. Tell them forget it. We walked away from it. We ended up selling it for almost $1.6 million, less than a year later.
Listing
So-
doesn't mean you're selling it. It means you're exploring your opportunities.
No, it means
If
that
no one's
when...
bringing any other
It
opportunities
means when an
to
offer
me,
comes to us, it's going to be
All right.
presented to us.
I have to interrupt you. Is this a filibuster? You can keep going.
Filibuster.
Otherwise, let's
It's the
call
longest
the question.
discussion we've had on the arena property in the last
Well, that's not
probably-
true.
And
You had
Pat
Steer,
loves
you had a
discussions.
lot of people in here. That's not true at all. But
Oh,
anyway,
it's really close to-
We have a motion or a suggestion that we call for the question.
Yes.
Let's do that. Motion to approve the listing with Cornerstone, and all the topics should go with it. We can cancel the listing at any time, is that true?
To be honest with you, I can't remember how we wrote it.
I don't
All
know.
right, then enter that into your contract, that you can, let's say proper no, let's say 90 days. How's that? 60 days.
Well, we'll have to see.
We have that all the time.
We've, I think in paragraph 21, there was something about being compensated for marketing efforts, which the 3,000.
Well, you're basically going to get your 3,000
Yeah,
up front.
yeah.
Basically, we get 5,000 up front, and we come back for more, because marketing is an expensive tool. You got to pay for the signs, and as you pointed out, I don't foresee a lot here, but nevertheless, that
what
is a
you're saying
tool.
is we
You would have
should
gotten your
We
3,000.
should have
let's say.
changed the 3 to 5.
Well, you can try that, but you see the opposition of just being friendly? We don't have friends up here.
But wait, I'm a former citizen.
And just to confirm, the termination clause just simply states that if we do terminate early, we're responsible for any marketing fees up to that point.
Yeah.
Which basically
it
is
says
covered
that,
in the
doesn't it?
rider, so it doesn't make it any worse. It doesn't have an adverse effect on us.
All right, so we can make that change. Do you understand the change we're asking for?
No, I think.
It's already in there. No, that's how it
already in
reads.
there.
I was just confirming
You're
that it
right,
doesn't.
you and I went over that, right? All right, so we'll call for the question. Let's have that motion to approve.
Motion's
think
already been
we had-
made, Mayor. The clerk just needs to call the roll upon your direction.
Okay.
Alderman Rosenthal.
Aye.
Alderman Messer.
Aye.
Alderman Dolan.
Aye.
Alderman Ludwigson.
Nay.
Alderman Williamson.
I believe the motion passes 3-2.
Motion carries.
Motion carries. Thank you, gentlemen, for coming.
Thank you.
Work
very
with the
much.
staff on finalizing the agreements. I think we all understand what they are. And let's see where we go with this.
We will meet with you.
I'm pretty well not here that much anymore, so I'll try.
Or
Any
Dan.
inquiries, you can come through me and I'll
Yeah.
notify the mayor and the
Okay.
administrator.
He's your guy.
Yeah, the city administrator is authorized in the resolution to sign the documents, so.
Okay,
All right.
very good.
Have a good evening.
Thank
Thanks
you.
for coming.
Thank you.
Do a
Thank
good
you.
job, Peter. I'll never talk to you again.